Let me yield to Mr. Gaetz and then Ms.
Yeah,
Hoffman.
I want to answer your question drawing on my 6 years in the state legislature. I believe that these standards organizations will draw their revenue as they typically have from their membership, right? So if you make a widget and you want that widget to be a part of the standard, you have an incentive to join the organization that is going to advocate for that widget to be a part of the standard. And that will be a sufficient incentive structure to continue to get that expertise. And the notion that if these folks can't charge for access to some of the standards they create in some way, that then people in the construction industry, in the fire safety industry are just going to say, well, we no longer care that the business, that we get to participate in the rules that govern the business we're involved in. I don't believe that that would dissolve. I think that would still exist, and the government would still be able to draw on that experience in the absence of the expanded government that would concern my colleague from Louisiana.
Would the gentleman further yield so I can answer that?
Let him respond, yeah.
The reason that fire chiefs and fire councils and firefighters are all supporting this is not because of the widgets. There are widgets in some cases, but in most cases where we're really talking about a fire occurs and a standard gets updated to say, you know, you have to have a sprinkler so many feet from such and such, and you need to have a certain amount of pressure. Those kinds of analysis of what happens, for example, in a fire safety situation, and the updated code, and the same, by the way, occurs in earthquakes and other construction. Those kinds of things don't have a product. They do have associations, but those associations, quite frankly, often would not have the revenue and would have no incentive of creating it. Thank you. I yield back.
The gentleman yields back. The time of the gentleman expired. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. Move to strike the last word.
The gentleman is recognized.
I want to circle back to Mr. Biggs' original point, which was sort of what happened, what led to a problem that needs to be fixed at this point. And as I listened, I think Mr. Fitzgerald said there was a court case that apparently had an impact. I'd like to know more about what that, or if there may be multiple court cases. I'd like to know more about what those courts ruled, what standard came out of them, and what it is we're trying to fix. And then to Mr. Bishop's point, I'm also a recovering litigator. If it could be sort of explained in the terms of, because I agree, so the Lexis piece, can't buy the law, you can get the comments and the like. If you have a treatise that's put online, that's a copyrighted document. And so you have the copyright for the document, but also for the comments that Lexis or Westlaw is putting in there. How is this different from that, I guess, is another issue that I just want to get a sense of what's the problem, what are we trying to fix, and how do we fix it? Because it seemed like apparently it had been working okay. Whatever the revenue stream that these entities got for generating these standards had been, and maybe still is, maybe they still are working, but something led to this legislation being required.
Would the gentleman yield for just a quick answer?
Would the gentleman yield?
I will yield to Mr. Issa first, and then Ms.
And I'll be very brief. You'll find multiple lower courts that have ruled that these standards are, that the taking and downloading in bulk was fair use. That often was reversed, but not without a fight. So that's one of the areas of great concern for these standard-setting organizations because, quite frankly, that litigation costs them to protect their own copyright, where normally a copyright holder would absolutely, when they won, get statutory damages and not have to go through this procedure.
Ms. Lofgren?
Yes, there is a recent decision from 2018 and we've entered it into the record. We'll make sure you get a copy of it on this very point. In fact, I submitted an amicus to that as well, where essentially those arguing that you cannot copyright the law prevailed. That was appealed, and most recently in the case of, in 2020 case, Georgia versus Public Resources Org, held that government published material is not copyrightable, and it was Justice Roberts who said no one can own the law. We will get you a copy of that as well.
You have a site for it, Zoe, by any chance?
Yeah, the district court for the appellate court in the District of Columbia and the United States Supreme Court. And we will get copies of both of them for any of the lawyers who want to read them.
I yield to Ms. Ross.
Thank you. I just, again, want to make this just very clear point about whether or not somebody can own the law. The question is, who created the standard in the first place? So when we talk about a court case, that is something that is in the public domain. It's something where everybody can attend. This is a situation where a private organization, privately funded, created a standard. The government then liked the standard and decided to shortcut, not pay to create its own standard, and adopted that. Here, the private organizations are willing to make that available. But if every time the government likes something that a private organization does and codifies it, that's a taking. There is no compensation for every time the government decides that a code, a private code, should come into the law. And that, I think, is the distinction between owning the law. So, of course, the world should see this.
Just to reclaim for a second, because I'm running out of time. I appreciate that. That's not the issue I had, though. The court case that I'm referencing was the one that apparently created the issue, because the approach that you just outlined apparently has been in place and running for years. So the question is, what's the change that led us to want to put in legislation to fix whatever the new problem is? Because I'm not clear on what the new problem is.
If the gentleman would further yield,
Yes,
the
ma'am.
standards organizations lost in court, and so they've come to Congress because they've lost repeatedly in court, and that's why we're here today. I thank the gentleman for
All right, Mr. Chairman, I know we're running out of time, but I would join in the suggestion that others have made that perhaps a hearing or some kind of additional opportunity to walk through this be provided so that we'd have a chance to go through some of the particulars.
Time, the gentleman's expired. I think we've got time for one more, Mr. Gaetz. We'll try to get to Ms. Hageman, but we may have to.
Thank you, Mr. Chairman, and I associate myself with the sentiment of Mr. Ivey that on a matter of this complexity, where I do think Mr. Bishop, Mr. Johnson, and others are trying to strike an appropriate balance, that a more fulsome review of where to find this line might guide us to a bipartisan landing zone. But when I'm confused, I tend to be the flavor of populist who thinks that the populace should have access to the law without having to pay even a de minimis amount. And there are a few reasons why. Like, in the most extreme, like what are we going to hear next? Road builders saying that you've got to pay to know what the speed limit is so that we can fund more roads? I mean, that would be the absurd extreme on one side. And then I also don't think that just because an organization collaborates with the government, that every thought they've ever had, every work product they've ever had, every manual they've ever had is all of a sudden in the public domain. So I do think that there is a balance, but I strongly reject the premise of the legislation that in the absence of these organizations being able to maintain a property interest that they can externally financially exploit, that they will just dissolve and cease to exist and have no interest anymore. And as we've been in discussions among colleagues, someone asked me reasonably, well, a bunch of firefighters are different than a bunch of contractors. So if some firefighters came up with something that was a good standard for fire suppression, then we wouldn't want them to be subject to the same lens that we would have someone that created a hurricane tie-down that they wanted in the state of Florida to be part of the building code. But I think that requires us to zoom out a bit. The whole premise for why something ought to be in a code or a law is because there is some public good. There is some public import to that. And the point that my colleague from California, Ms. Lofgren, made earlier that I would like to double stomp is the notion that proliferating these codes and ideas actually can yield better public policy through clash and discourse and debate and review and questioning, and whether that's the latest sinkhole technology or fire suppression. I'm reticent to support legislation that I think could be limiting of that type of collaboration, particularly on matters as important as like whether people are going to live or die in a fire, or whether or not when an earthquake hits, people are going to be safe as a consequence of the building codes. And I also worry about the litigation that this bill could spur that we're not thinking about. We've had some discussion of the litigation that brought us to this point, but in a world post this bill, could you be in an environment where people believed that they were engaging in, putting on a seminar about building codes or about fire suppression, and they start using things that then they're getting hammered in some intellectual property context for. So while this is complicated, what I think the public needs to understand observing this debate is the purpose of the bill is to maintain within a standard organization a property right that the courts have said they do not have.
Correct.
And it is to maintain that property right to personally, to financially exploit it. That is, I think, the premise, but I would yield to the gentlelady from California.
I thank the gentleman for yielding. I think, it's not correct that these various standard settings groups would fall apart absent charging the public for finding out about the law. For example, the American Society for Testing and Materials in let's see, I'm gonna get the right. They had, and their executive was compensated $4,500,000. Their revenue was over $100 million, and it was made up of their manuals, training documents, other materials.
We seem to be in the wrong business, Mr. Lofgren, but I'm going to reclaim my time to yield it to Mr. Madison.
So what are standards? Standards are things that are in common use. And let's just take an example. You might be able to copyright the format of your font and the arrangement of things, but you can't copyright the rise and run of a pipe for proper drainage in your plumbing system. 1/4 inch per inch shouldn't be copyrightable to start with. That's a notion. These are physics, these standards are, and they're in common use. So I think you do get to own the fonts and the charts and the graphs and all that, but you can't own the concept as it goes into law. This isn't the weaponization of government, but this is the monetization of legislation, in my opinion. I yield back.
Gentleman,
Yield back.
Gentleman yields back. We will stand in recess until